5, 4, 3, 2, 1. The prayer of the petitioner in the application was only to receive the document by way of secondary evidence. The relevant part of Section 65 of the Indian Evidence Act reads as under: cases in which secondary evidence relating to documents may be given. Secondary evidence may be given of the existence, condition, or contents or a document in the folio wing cases. A. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process or the court, or of any person legally bound to reproduce it, and when, after the notice mentioned in section 66, such person does not produce it. The provision under section 65 of the Indian Evidence Act rulers that one who propose to rely upon a document by invoking section 65A of the Act should give proper notice to the person concerned to produce it before the court. It is not in dispute that there was a notice issued to the respondent herein under section 66 of the Indian Evidence Act for the production of the original of the document in question. It is also not in dispute that the respondent came forward with the reply to the notice that there is no scope for producing the original, inasmuch as, according to the respondent, there is no such document in existence. The expression used under section 65A of the Indian Evidence Act is when the original is shown or appears to be in the possession or power of any person legally bound to produce it. The statute does not say specifically show that for the purpose of invoking section 65A of the Act, one should assert that the document in question is in the possession of the party concerned. It is sufficient if the petitioner is able to demonstrate that the said document is appeared to have been possessed or by the concerned person. The whole basis of which the petitioner laid the suit was that there was a partition between the respondent and the other members of her family, including the first defendant, namely Raghvendran, that it was by virtue of the said partition entered into between the parties, the suit schedule property fell to the share of the said Raghvendran, who in turn conveyed to the petitioner. According to the petitioner, at the time of the execution of the sale deed by the said Raghvendran in favor of the petitioner, the original partition deed was produced and shown to the petitioner by the vendor. Therefore, going by the above factors, it is beyond doubt that every facet of Clause A of Section 65 of the Indian Evidence Act is fully satisfied in the case on hand. Therefore, there should not be any impediment for the court below to receive the document in question, subject to the proof of the said document, so as to rely upon the same at later point of time, I am of the view that to reject the receipt of the very document at the threshold under the facts and circumstances of the case is totally unjustified and not in accordance with law. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है।